Tuesday at from 5 to 6 p.m. Along with me is my business partner. Emily, what do we have to discuss today?
Yeah, today we want to talk about the H-1B visa lottery for cap subject petitions that's coming up soon. Unlocking the mystery of the lottery will provide you a step-by-step guide of what's needed to get through that process, the important timelines to be aware of, and just tips and tricks to make it through. We also want to talk about a very common issue that's happening right now with the job situation with layoffs happening in the tech sector is your adjustment of status application is pending and then you lose your job. What happens in that situation? What are your options to be able to actually receive your green card? And we're seeing a lot of requests for evidence on I-485 applications, interviews happening for 485s, even when the priority date is not current. So we want to talk about, is that common? Is that something that normally happens? And what about the cases where the priority date is current? What are the processing times we're seeing for that? So on the H-1B lottery, a couple of dates for you to be aware of. Well, first of all, who has to go through the lottery? To anyone who has not held an H-1B in the past or who has obtained a cap exempt H-1B because of the type of employer they were working for and now they're switching to a for-profit employer, or anyone who's used up their 6-year limit, stayed outside the US for 1 year, does not have an approved I-140 and therefore has to go through the lottery again. The lottery is the electronic process. This will be our 4th year now of having the electronic registration. For employers, February 21st is the date that they can log in to create their registrant account. If they've already have an account from a prior year, as long as they have access to it, they don't need to do anything different. They don't have to create a new account. This is just for employers who don't already have the account. So February 21st is the important date for that. They have to make sure the company is creating the correct account. There are different types of MyUSCIS accounts. So the one they want is called the registrant account. Then the actual cap happens, the lottery, where we're submitting the registrations from March 1st through March 17th at noon. All of that is done online. We submit everything for each company, all of the employees that they're looking to register. Then we get a passcode, we send it to the company. The company logs into their registrant account, enters that passcode, accepts the registration, accepts our G28 that we represent them, and then the case goes back to us. We then log in one more time and pay the $10 fee for all of the registrants in that particular group. So that's kind of what the process looks like, March 1st through the 17th. We've been getting results of the lottery around March 31st, so hopefully we'll see the same, and then we can start filing April 1st all the way to June 30th if you're selected. And then the approval notice will actually start on October 1st. So that's kind of what we're looking at as far as the timeline and when different steps happen. What are some of the issues that people should be aware of as they go through this?
Emily, I don't want people to wait until March 17th. The computers may break down, things can go wrong. 12 o'clock means it's not Central Time, it's not Pacific Time, it's Eastern Time. I would definitely want people to register within the first week. They don't have to do it on the first day. There's no importance that if you register on March 1st as compared to March 10th, it'll all be the same. You'll be in the same lottery. It will not be different though. A lot of people, Emily, they fall into the trap of these employers registering even if they don't have a job. Let's say if they're working for one particular consulting company, they get registered from that consulting company. That's very good. But of course, they go to other consulting companies, not so good consulting companies, and they file a duplicate application though. And surprisingly, if they get selected, they move on to those companies. But the problem here is, Emily, the USCIS is watching these people. They have algorithms of who are the people who are filing when they're not working for the company. And out of the cases that got selected, how many people they did not come and file these H-1Bs though. Then they go and do the inquiry with those companies, and these companies will just either move out of the country or they make a deal with the prosecutors and they say that they submitted all these H-1Bs in a fraudulent. So if you're not working for the company though, if they are filing for you, we do not recommend that you do file those things. And if you find the companies that are offering, I've seen a company, Emily, on the Facebook, they said, within 1 day, we're going to file the H-1B. They didn't ask that guy's resume. All I need is the passport information, your date of birth, and whether you're a master's degree or not, which is required for filing the H-1B. and they're going to file it. I mean, how? You don't need a resume. You don't want to interview that. And of course, that company was later on found to be fraudulent. USCIS investigated even after the H-1B is approved. Even after those people transferred to different companies, they went and revoked it. Those hundreds of those people's lives from that company has been destroyed. So I want people to be careful when you go to these companies, because you don't want to support fraud and get involved in the fraud, and then later on your life will be in suffering. If you find those companies, though, you can report to this fraud detection unit of the USCIS. You can go to RN Law Group, Fraud USCIS. There is an email address that we provide. Report about these companies, though. That's better, because we don't want these companies to spoil the lives of the other people. We don't want these companies to ruin the legal system that we set up in the United States. And the reason why we are in USA is not because they are producing the best engineers, but because this country follows the law much more than any other country in the world. And that's why you guys, most of you guys are engineers that are listening to us, are here. This country may not produce a lot more engineers than what India does, but they do have a very good legal system that catches on eventually. Sometimes they may catch it immediately, sometimes they catch later on. So we want you to respect the laws of the United States, follow the laws of the United States, and make sure that you don't fall into the trap of those companies. So, Emily, what was the previous year's lottery system? It seems that every year, since we have this $10 registration. Now, previously we have seen that if they have to file a H-1B, they have to file the entire H-1B application, including the filing fees. So we didn't see a lot of duplicate filings of fraudulent at that point of time. But now they have created an online system, and now the numbers have gone up. Of course, the economy went up also from 2020 to 2021 to 2022. Now, what do you expect this year, though? Now, we call this as 2024 fiscal year because the October 1st is the start date that we're filing. What do you expect? What was the previous numbers? What do you expect this year?
Yeah, so back under the old system, the highest it ever was about 236 petitions were filed. That's when we had to submit the entire thing, filing fees at all. Then they would run the lottery, and then they would send half of them back that didn't get selected. That went back to April 2016. Since April 2020, we had the online system. We also had COVID at that time, just getting started. So the number of registrations in 2020 was about 275,000. The next year, it jumped up to 308,000, and then last year was 483,000. And of that, only 127,000 were selected. So 300,000 people did not get selected. Of course, a lot of those were duplicates, so we can't say there were 482,000 people in this lottery. We don't know how many individuals there actually were. I don't see any reason why it's going to go down. I'm thinking over 500,000.
I'm thinking because there was a lot of prosecutions that occurred for the companies that filed the duplicate applications. These companies, some of them went to jail, but some of them have not been caught. I know some of the companies have not been caught, but there are a lot of companies are in investigation, though. That could be a reason it may go down. That's my expectation. The second thing is that, of course, the economy is not as good as it was when it was March of 2022 to March of 2023. The economy seems to be slowing. So my expectation should be lower unless these fraudulent companies go more fraud and ruin the lives of the individual employees.
Yeah, which they might go more because, again, the filing fee increase hasn't happened yet. They're thinking about raising it to $250.
I don't like $250. I would rather want the entire filing fees to be filed when they file a H-1B. Yeah. In that way, the fraud goes down, though. But of course, a lot of people, Emily, they don't listen to us, but then they come to a consultation when they get into trouble. Every week, I get to speak with the people, 3 or 4 employees who got ruined by this one. And I tell them there is nothing you can do except that collect as much money as possible from your employer for the wrongdoing by filing a WH-4 form. That's what I tell people, though. But if they but we cannot save them at that point of time. They will have to leave the country.
Yeah, one more thing to consider for the H-1B lottery is if your OPT is expiring before June 30th, even though you have until June 30th to file your H-1B if you're selected, you actually need to file it before your OPT expires so that you get the automatic cap gap. So the cap gap will automatically extend your OPT through September 30th to allow your H-1B to kick in on October 1st, but that's only if your H-1B petition is filed before your OPT expires and it requests a change of status from F1 to H1. So consular processing doesn't work, and it requests a start date of October 1st, which is usual for the H-1B. So just keep that in mind if you are selected and have an OPT expiring.
Emily, the lottery is conducted, end date you said is March 17th, 12 noon Eastern Time. What if I'm graduating in May of 2023? Can I file in the master's quota in this year's lottery?
Yeah, technically you can. So even though during the registration you might not have the master's degree, as long as you'll have it before June 30th, you can still file in the master's cap and be selected that way. And then just wait until you either have the degree or can get a letter from your registrar confirming that all of the degree requirements have been met, and then file the H-1B. So the only problem would be if for some reason you don't graduate, then if you're selected
in the master's quota,
that's going to be a problem.
What if I'm the first year of the master's student? Can I apply in the bachelor's quota?
Yeah, absolutely.
A lot of people are under the mistaken assumption that if you are studying in the master's, if you have a job offer, you can apply in the bachelor's quota. You are not eligible for the master's quota because you don't have the master's degree in USA, but you are still eligible for the bachelor's quota, though.
Yeah, I think a lot of people think you have to be an F1 student to get into the master's quota, but if you have a U.S. master's that qualifies, you can be an H4, you can be an L2, you can be an L1, you can be outside the U.S.
and still apply in the master's quota as long as you have a master's degree in USA from an accredited nonprofit university. Then you're good to apply in the master's quota. Anything else, Emily, before we move to the next topic?
Next topic.
AO is pending, and I'll ask my job, what is the solution, though? First thing, adjustment of status is also called as I-485. I mean, it took a long time for you to get here. Our main purpose is to make sure that your 485 is safe. Now, a lot of people ask me the question, do we have the 60-day grace period that we have in the H-1B and adjustment of status? Maybe not. We may not have the 60-day grace period available in the adjustment of status. The rule says that you must have a continuous job offer in a similar profession. Let's say the Microsoft has laid you off and your last date of employment is March 20th. And now you're going to wait for about 40 days to find a job, let's say some other company though. Is it okay? We don't know the answer to that question. We don't know how the USCIS interpret though. The best solution for you would be that if you lose a job and you are on adjustment of status, okay, assuming that you have an EAD, there are multiple different options. I'm going to go with the hierarchy of it. What is safer option? Obviously, you get a job in Google before, and as soon as you get laid off from Microsoft, you join Google or any other company, Deloitte or any other consulting company. You're fine, you're good. Now people ask the question, do we need to submit the 485J supplement before joining the company, at the time of joining the company, or immediately after joining the company? At this point of time, it's not absolutely required that you need to file a 485J supplement. You can do so at your leisure, or when there is an RFE or when there is a 485 interview, you definitely need to take a 485J supplement. That is telling that you have a job offer from a different company than the company that filed the I-140 or 485 for you. Now, that's the best solution, is to join another company. The second solution, which probably we recommend that you contact a lawyer, though, is that if you get a job offer from company B, okay? So you lost the job from company A and you got a job offer from company B, and you're taking time to join because you've been working for 15, 16 years to get here. Maybe you want to take off some time to join the company B. If you have a job offer, just a job offer, a letter may be a good, and sometimes 485J might be good too. If there is a job offer from company B, it may be okay for you. Now this is a little bit gray area, but under the circumstances, if you don't have a job immediately though, if you have a job offer from somebody and you want to take off for a certain time, it may be okay for you to do that thing. And if you can't even find that one, the third best option would be to have your self-employment. Is self-employment allowed in the adjustment of status? It's definitely not allowed in H-1B unless you form a company. There are some very rare exceptions available. But when it comes to the 485, self-employment is allowed. It's technically allowed. Emily has gone to a couple of interviews. We have been able to successfully defend on those things. Self-employment is the third option. Now, of course, the USCIS is going to look into, is there a genuine job opportunity open for you, or is it not a genuine job opportunity? Was there a real self-employment? Was there not? I would recommend that if you get to the position where you don't have a job, I definitely recommend that you contact an immigration lawyer to strategize so that your 485 cannot be denied. One of the strategy that I normally adopt is that I don't file a 485J supplement when your wife is employing you, or when you are self-employed, or when you have this job offer you haven't joined. I don't do the 485J supplement. I may do the 485J supplement at a later date, though. When you landed in a very nice job and very good circumstances, at that point of time, you may submit the 485J supplement, not initially when you have a job offer or when you're self-employment. Is self-employment legal? Yeah, perfectly, it is legal, but it always leads to a lot of questions, interviews, and the officer might not be comfortable about that. That's the reason I don't want to file a 485J supplement. Any thoughts on this, Emily?
Yeah, I think the most important thing, or the riskiest situation you can be in, is if while you're looking for a job or you're between jobs, you get either called in for an interview or you get an RFE asking for the supplement J. We don't typically see those supplement J RFEs unless your date is near becoming current and your application has been pending for some time, or perhaps the old employer withdrew your I-140. That sometimes can trigger the supplement J RFE. But if there's no RFE and there's no interview happening, do we want you to hang out with no job forever? No, but you're in a somewhat safe situation where you have options and you can be looking, and if the interview happens or the RFE comes, then you can make a decision about finding a future job offer, as you discussed, or self-employment, or having your spouse open a company and working for your spouse's company. So I would only take those options if I'm in a situation where I have to submit the supplement J because I've either got an interview and RFE.
A lot of people are getting RFEs for medicals, and people are getting interviews for the 485 applications, which they filed long time ago. And the final action dates for these people is nowhere nearby. Most of these priority dates are in 2014, and people just bang their head. What happened to my 485 application? Am I in trouble? What's going on? Why am I getting an interview? Why am I getting a RFE? It is perfectly all right. They want to pre-adjudicate your application. It's a good thing that they are doing it. They're working on the file to make sure everything is okay, so that when the priority date becomes current, they want to adjudicate your application. Nothing wrong with it, and a lot of interviews are happening. No problem, but always we recommend, if there is a 485 interview, please have a mock interview done by an immigration lawyer. Go through the documents, go through all the things, what they could ask, what your answers are. Speak with your immigration lawyer, or speak with an independent immigration lawyer to go through the things, have a mock interview done so that you're well prepared when you go for the interview. Sometimes we recommend people to take a lawyer to the interview. Sometimes I'm okay if you go without a lawyer. Depending on situations, lawyers will advise you whether or not you're recommended to take a lawyer, or it's up to you to take a lawyer.
Yeah, I definitely recommend the mock interview because I feel like there's a lot of misinformation out there. There's a lot of blogs and articles, and this is what happened in my case, and that might have been 10, 15 years ago. And so everyone thinks that their interview is going to be similar, but interviews that change over time, and you want to make sure that you're preparing correctly and not preparing based on what happened in someone else's interview in a completely different type of case, different situation, different field office, and years ago. So I do recommend the mock interview. It just helps you feel more comfortable and confident, which is also important when you are in that interview. It does make a difference with the officer, I think.
A lot of people are, we're going to go to the question and answer. We'll try to answer as much as possible. But don't forget that we do have a daily Zoom call, guys. It's free. You all guys can come in and ask the questions. And the link is provided at the bottom of this video. So you can join the free conference call, free Zoom conference call to ask questions. They're not, here it's not thousands of thousands. Only like 50 people are really there in those things. We do answer a lot of questions in those. So please try to use that service if you can.
All right, going to the questions. Kamlesh has an EB1C concurrent I-140 and 485 that were filed back in September 2021. I-140 finally got approved this week and got the EAD, but no AP yet. And he wants to know, when can I expect this to be transferred to a field office? And when can I get the green card? Can I visit my home country now? Can I change the job now? Okay, so the processing times for the 485 are, the last one I looked up today was 22 months. So if you filed in September 2021, you might be looking at August 2023 for your approval, which is ridiculous. But that is what they're doing these days, especially for cases where the I-140 just got approved. Your case may never go to the local field office. A lot of the EB1 485s are transferred to the National Benefits Center and adjudicated without an interview. As far as when that transfer might happen, no rhyme or reason to it. I had several that were transferred before the I-140 was approved, but they're still pending from a year ago. And I have others that are still stuck at the Texas Service Center after the concurrent filing. So hopefully you would get your green card before the end of this fiscal year in September. Whether you can visit your home country. So you mentioned you don't have the advanced parole, and you mentioned that this is EB1C. So it really depends on, do you have the L1A still valid, and do you have the visa stamp? If you don't, you either need to make sure you can get an appointment and don't get stuck with the 221G, or you need to wait for that advanced parole. But yes, you can change the job now. Your 485 has been pending for 180 days. Your I-140 is approved. As long as the new job is similar, it can be with any employer. EB1C does qualify for AC-21 just like any other job does. So you can change jobs at this point.
Shiva Prasad has this question. Perm audit. Based on what you're telling is a notice of filing documentation, recruitment documentation, and a recruitment report. These are normal audits, Shiva. I wouldn't be asking for a second opinion from a different lawyer if the audit like this comes in. I mean, it's a very, very normal audit. In fact, nowadays, it's become a little bit more common to get the audit though, as there is a little bit more unemployment in the IT field. That probably is the reason they are increasing the number of audits though. But that audit that you have seems to be very simple. The lawyer that you have should be able to handle that. Ritika Chanda has this question. Can I go to H-1B stamping to Canada? This is my first H-1B stamping, or do I have to go to home country? Ritika, you can go to Canada for H-1B stamping. You don't have to go to India for the first H-1B stamping.
Krish says, I'm an EB2 straight filer, so I already had the I-140 approved and filed just the 485, still maintaining H-1B, and wants to know if I travel back on AP, will I be able to file a new 485 and EB3 when that date becomes current? I already have the EB3 I-140 approved. So when you come back on an AP, we do know that you can extend the H-1B, you can transfer the H-1B, you can file a change of status from H-1B to something else. What we don't know is, can you file the 485? So what we recommend in that situation is, once you come back from your home country on AP, you take another quick little trip to Mexico, use automatic revalidation, the margarita switch, show your H-1B approval notice. You'll get a new I-94 putting you back in H-1B status. You don't need a visa stamp to do that, because they'll use your expired H-1B visa or your old visa that's in another category. And now you're back in H-1B, and now you can file that second 485 without having any risk.
Question from Sandeep from Facebook has this question. How long can somebody continue to work from India, working from home, especially if their case is stuck in 221G? Well, you can work for 1 year. There's nothing wrong with it. You're an Indian citizen. An Indian citizen can always work in India. You don't need any work permit for immigration. You don't need any work permit. You don't need anything. You can work. Now, if you get stuck with 221G and you want to come here faster though, you may want to consider suing the consulate though. You can contact our litigation lawyer. His name is Stephen Brown from our office. Just send him an email or send an email to info@rnlawgroup.com, and I'll forward it. He will contact you to make sure if your case is worth taking the federal court. And People are wondering, wow, is it going to cost tens and tens of thousands of dollars? No, that is not true. It is reasonable. I mean, it costs less than filing fees of the H-1B in most of the cases, though, is what it costs to go to the federal court in litigation. So you may want to try that because it's probably less than the total filing fees, including premium processing fees. It's probably less than that when you go to the court. So the court fees is not that high, guys. Of course, lawyers charge money, but yeah, it's far less than some of the filing fees you guys pay, the companies pay.
Sai says, can we renew the AP I-131 by ourselves, or should we renew through a lawyer? Totally your choice. I mean, everything in immigration, you can file it on your own. Your company doesn't have to use a lawyer. We, of course, recommend you use a lawyer because the lawyer is going to know what the correct filing location is. They're going to know exactly how to fill out every part of that form. It is a bit of a confusing form. All of the immigration forms are confusing these days. The filing address charts are confusing. So if you want to know that it's done right and done on time, I do recommend using a lawyer, but there's never any requirement for
Well,
you
if
to do
anybody
that.
wants to contact our office, guys, we charge just $150 for EADs and advance for each applications, though. But you can contact us at info@rnlawgroup.com.
RB wants to know, what documents do we need to preserve after receiving the green card? Can we shred all of the H-1B documents, or are they needed for naturalization? So in most naturalization cases, the only document you submit is the copy of the front and back of your green card. They don't ask, you don't have to submit all of your old H-1Bs, I-94s, visa stamps, anything like that. Do you think they need to keep any of those documents?
I don't know, for some reason, it's been long that I became a U.S. citizen now, almost 20 years. But I still keep those things. I like to look at the EAD card, though. It's different. Yeah, I still kept them for some reason, but yeah, no, absolutely. I never showed it anywhere to anybody. Once I got the green card, green card is the only one that you need to show.
Sriva says, is it okay to reschedule a 485 interview for EB2 when the priority date is not current for January 2014? If so, if not, why? I generally don't recommend rescheduling if you can avoid it, because it puts you in the bottom of the stack, the back of the line. Those cases fall through the cracks so many times. You may never get your interview appointment again, even when the date becomes current, because they've lost track of your case. So if there's any way you can attend that interview, please do it. Do try not to reschedule.
It's definitely not advisable to postpone it, guys. And people, you're waiting for decades. Now you don't have time to go for the interview. Really? You want to deal with us in the long term? Believe me, you should not like us, guys. Okay? You should not like us that much that you don't want us in your life for a long period of time. You need to try to get rid of as soon as possible. That's the whole reason we have this channel, is to get rid of the immigration lawyers as soon as possible. If you are in India, come back. It's worth. If you don't get the ticket, fly in business class. Don't pay immigration lawyers. Pay the airfare in business class. That's better for you. Believe me, I have gone through the immigration journey and I'm an immigration lawyer. I understand both sides of it. It is not worth postponing the 485 interview.
Harry says, could you kindly explain when the kid's CESPA age is locked? I'm informed by my company's attorney that our priority date needs to be in the final action date all the time, from the time we file to the time the AOS is approved. Not true. So in order for it to be locked, your I-140 has to be approved and your final action date has to be current at one point, and your kid has to be under 21 or a CESPA age under 21 by subtracting the amount of time the I-140 was pending. But if the final action date later retrogresses, your kid is still locked. They never become unlocked once they're locked. So it can take 40 years, and your kid might be 40 years old and still be able to get the green card with you.
Emily, I need some help. I know you had some update. I was not part of the discussion between you and Stephen. The number of green cards that were wasted the past 2 years, and people are asking the predictions for EB2 and EB3. Did they waste it last year also, the green cards?
So it's a little unclear. We got some new data that came out from both USCIS and Department of State. So USCIS says this is the number of 485 adjustment of statuses we approved in the employment-based categories. And the Department of State gives the number of how many immigrant visas they issued in the employment-based category. And we add those two numbers up, it's about 20,000 less than the number of green cards that were available.
So who ate them?
Right, we don't know. There's a little bit of confusion because some of the charts they claim, well, this chart only talks about immigrant visa admissions into the U.S., not visas actually issued at the consulate. And this other chart, for some reason, it includes EB4 other workers in the numbers. So it's very confusing. And then there's one other chart that normally comes out by now that is not out yet. So nobody knows exactly how many employment-based green cards were issued last year.
But on September 6th, they said that there are no green cards available.
Right, yeah. So if they actually had 20,000 more,
that means they lied.
Yeah, exactly. So we're still researching that, still waiting for that last chart to come out to know exactly how many green cards were issued last year. And for sure, we'll be monitoring that.
We'll be monitoring if required. We'll do the class action against USCIS. We'll ask you for funding, guys, because that requires a lot of things. And you know that the class action suit that we were part of it, and the H-4EAD got benefited 400,000 people who's when they are moving from H-4EAD extensions, and sometimes the USCIS takes a long time. Now with the class action suit, now they said they're going to approve the H-1 and H-4 and EAD together. That's a very good news. So we'll look forward for any of the weaknesses, where the USCIS is doing anything bad. We may take to the class action. We may come for you for funding, GoFundMe or something like that, so that, because it takes a lot of resources, money from us, and we don't get paid. But if it is for public good, we would like to bear some burden, but also put some burden on you guys to support us in those activities.
CA says, my cousin got his H-1B petition approved in October 2020, went for stamping in February 2022, a year ago, got the 221G and has been stuck there since. He's never entered the U.S. What are his options now? Is a lawsuit possible? Yeah, a lawsuit is pretty much your only option at this point, other than continuing to follow up with the consulate. You can, your cousin can contact a senator, or his employer can contact the senator or congressman's office. It does no good. The consulate just says it's an administrative processing. There's no way to expedite it. You just have to wait. But filing a lawsuit does get things moving. We've been doing that for a number of months now. We've seen a lot of success in people being able to finally get the visa issued after waiting for months and months and months. So yours has been pending for a year now. It's primed for litigation. So please contact Stephen Brown in our office, stephen@rnlawgroup.com. You can go to rnlawgroup.com to get more information about litigation, what exactly we do, as well as to get Stephen's contact information.
Srilata has been laid off from the job. She's on H-1B and the 485 with EAD. And the new company might take 2 months to give a solid the job offer, though. This is where exactly we were describing, though. You can find some other company to give a job offer. It can be a small consulting company. You could be self-employed. You can be employed Srilata by your husband if you're nice to him, of course. You can. The reason here I would recommend you to contact an immigration lawyer is there are two things here, Srilata. We already know that H-1B has 60-day grace period, but we don't know about the 485. In the 485, the regulations doesn't prescribe that whether you can have a 60 days unemployment period. It does not prescribe that. So my main intention when people contact me is to keep the 485 active. And sometimes I may want to sacrifice the H-1B for 485. That I may do it, though. That's because for me, 485 is the most important thing. I don't care about the H-1B. You already have an EAD. So I would want you to contact an immigration lawyer to be on the safer side, because there are certain steps that you need to take care right now. Because if you have a job offer either from your husband, hopefully so, he likes you, or from any other company, though, it's better that we have a documentation right now. It doesn't have to, you can't create a document at a later date saying that, okay, I have a job offer in those 2 months from a different company, so I should be good. So it's better that you contact a lawyer right now rather than at a later time.
Ankit says, my I-140 is still pending. I just got my EAD approved. I'm in the EB1C category. What are the benefits and how much time will it take to get the I-140 approved? It was filed in October 2022. So at this point, it's not safe to use the EAD. So there's not a whole lot of benefits right now. I would definitely recommend waiting until your I-140 is approved before you use the EAD, before you think about using AC-21 to switch employers. And the reason for that is if your I-140 gets denied and you are using your EAD, it's going to cause your 485 to be denied. And now you can't use the EAD, you're out of status, potentially unlawfully present if your L1 has expired by that point. So having the I-140 denied is pretty much the #1 reason that I-485s get denied in the employment-based category. So wait until your I-140 is approved before utilizing that EAD. Now, how much time will it take to get the I-140 approved? In regular processing, it routinely takes a year. So it may not be until October of this year, but premium processing is now available, so you can pay the extra $2,500 filing fee to ensure that you get the approval. I believe it's within 45 days for this type of case. So you may want to consider that, especially if you're looking at a potential job change and want to be able to use that EAD.
How long before can the employer post the job for the POM? And this question is from Kiran. He's waiting for the prevailing wage. I recommend 2 months before the prevailing wage determination time. So if the prevailing wage is going to come, let's say for example, 2 months from now, that's when you should start posting the advertisements. That's the recommended time. Now, I want to explain the people who don't understand what his question is. There are 2 ways normally a POM processing can be done. You wait until the prevailing wage comes in. Once the prevailing wage comes in, the employer starts the recruitment process by posting the job notices and posting in the Sunday newspapers and whatever other requirements are there for the POM application. But what happens is that by the time you are going to waste a lot of extra time for, you will waste 2 months extra time though. And the person's H-1B may be expiring though. There are a lot of different situations people would like to have their POM approval fast. So they could start the recruitment process early though. There are some disadvantages, but the major advantage is that you gain about 2 months. Is it 2 months or 2.5 months do you recommend, Emily?
I would say 2 months. The only caveat is if the prevailing wage is going to come in July, then don't do anything because July is when next year's wages come out and we can't predict what that wage is going to be. So you might do the notice of filing that has to have the wage in it and end up having to repost it because the wages came out higher than what you expected.
So at the most, you have to repost it, right, Emily? But there's no
so you
penalty.
lose 45 days.
You lose 45, but it's not. I mean, you don't gain.
Right.
Yeah, you don't gain any there, and you may lose some money for advertisement. That's all. Yeah. But otherwise, not a big penalty in those things.
Let's see. Zulfikar said, my STEM OPT application is pending with USCIS for 75 days. The initial OPT is already expired. He has the valid F1 visa stamp, has the STEM OPT I-20. Can I travel to India for 6 weeks on unpaid employment? No. Once you have to have the valid OPT card, either the initial one or the STEM extension in your hand in order to come back to the US. So you should not travel in that situation. You need to have the I-20 given for travel, but you also have to actually have the OPT card. And remember, your OPT is automatically extended for 180 days based on having the STEM extension application pending. If you were to leave, you lose that auto extension as well. So I definitely don't recommend travel until you get the STEM OPT card in your hand.
Ricky has responded to the RFP for NIW. It's been 3.5 months. He has raised service request. His priority date is Jan 2022. I recommend to file the premium processing for NIW. Premium processing option is available because we don't know if the rest of the world is going to take a backlog. We don't know. At this point of time, Ricky, I would definitely do a premium processing if I were you. Emily, I have one thing that I want to debate with you because this question pops up very much nowadays though. And this question is coming from CEO Sonic Solution. Here is what he wants to do. He is on GCEAD. He wants to open his own company and he wants to work. And he's going to work immediately but it may take a little bit time for the revenue generation. What do you advise? Should they, and this will be the primary employment?
I don't see any issue with that. You could consider continuing with your existing employment and getting that going on the side until you get some revenue generated. But definitely a lot of people are doing it, have done it.
Yeah, Emily is a very, aggressive lawyer compared to me. I'm a little bit more defensive when it comes to the GC, you owning the company and you sponsoring yourself on the 485 when it's needed. Though I'm a little bit more defensive on it. But we have gone through the 485 interviews, Emily, and we've gone through the 485 interviews. Whereas a self-employment, we never had any denial, though. We just have to make some extra argument, make the officer understand. And there is a clear memo from USCIS that says that self-employment in the similar field is perfectly allowed for the AC-21 law to kick in. That means to move to a different company. I'm a little bit more conservative here. But I know Emily is more aggressive than I am in that.
Sundeep says, any downside or negative impact on me if I file a lawsuit against an ex-employer for wage violations? So generally, no. I would say that if these wage violations are related to an LCA, if this is while you were on an H-1B or an E-3 or something like that, you're probably going to have to go through the Labor Department rather than a lawsuit, because the Labor Department is in charge of all that. And that's done on the WH-4 form rather than through a court. But generally, any litigation, we've been filing a lot of lawsuits over the years, and we've never had a client that had a negative impact. There's no such thing as retaliation by the Immigration Service because someone filed a lawsuit. You're exercising your right as someone who is utilizing a government agency to receive a benefit, your green card, your H-1B, whatever it might be. And the law says that you have the right to sue them if they're acting unreasonably.
Emily, if there is an option of the LCA violation, let's say, for example, the company is supposed to pay $120,000 in the LCA, they did not pay 3 months of the salary. Would you choose to hire a lawyer, or would you go with the WH-4 form, filing with the Department of Labor, or contacting the employer directly?
I would go with a lawyer. And the reason for that, kind of what our strategy is, we fill out the WH-4 form, but we don't send it to the Labor Department. We send it to the company with a demand letter saying, hey, you've done all these things wrong. We are threatening basically to send this to the Labor Department, and they're going to open up an entire audit of your company, not just this one guy. But, if you take care of our guy, maybe we'll not do that.
Yeah. And then sometimes what happens with this WH-4 form sending the Department of Labor is your company might just go dead. Mm-hmm. And you may not be able to collect the money once the company go dead. So I would rather want to collect the money for my client first. Then I don't care after that whether my opponent dies.
Kieran says, I heard that if the perm is filed and waiting on a decision, and I'm almost at my 6-year limit of H-1B, I can get an extra year because I'm waiting on my perm. Kind of. So in order to extend beyond the 6-year limit based on a pending perm, the perm had to have been filed 365 days or more before you reach your 6-year limit. So if you are reaching your 6-year limit and your perm was just filed, that option is not available to you unless you exit the country and then later come back in and recapture the time you were outside the U.S. You're basically extending out when you're going to hit that 6-year limit to try to get it to 365 days from the time the perm was filed. Otherwise, you have to have both the perm approved and an I-140 approved in order to extend beyond the 6-year limit.
How long does the field office take to process the I-485 after the medical RFA response is received by the officer? Prior date is correct. They can adjudicate at any point of time, though. But one thing, Madan from YouTube, one thing is that if it's been more than 1 year that your 485 is pending, you may want to consider taking your case to the federal court, though. The adjudication process may become more smoother and faster because your prior date is current, you're lucky it's current. Who knows? It may go back. So I would definitely consider taking it to writ of mandamus, where you take your court case to the court instead of waiting for you to get adjudicated, though.
Kamlesh says, which center is the National Benefit Center and what is the processing time for the 485 there? Yeah, that's a little confusing. So it's the Missouri, it's in Lee's Summit, Missouri, and they call it the National Benefit Center, or NBC. The processing times are not published for the NBC. How you determine your processing time is look up your field office to see what that office's processing time is. But there's no separate processing time for the NBC. We were seeing, when they were hurrying up and adjudicating applications, anywhere from 40 days, 50 days, 6 months, 8 months at the NBC. But now I've got applications pending there over a year with a current priority date. So they've definitely lost their motivation to adjudicate these applications, and we're back to the old 2-year processing times. Naveen says our perm time frame's also getting pushed out. Our priority date is June 2022. Seems like our case would be adjudicated March, April 2023. Yeah, they're getting longer and longer. Prevailing wage is getting longer and longer, and the perm processing time is getting longer and longer. 7, 8, 9 months is pretty standard now. So that is not unusual, and it doesn't seem to be like it's going to get any better anytime soon.
Ramakrishna, I got a new job offer from a customer, but they are saying that they're going to file an I-140 after 1 year. You mean it's a perm application after 1 year. But my current employer is planning to file I-140 in March. Which one I need to choose? I-140 of customer job. I-140, the company that files the perm application in March. Believe me, you want peace in your life. A little bit hike in the salary in the long run won't make much difference. Having been counted toward the H-1B number, having an I-140 approval for more than 6 months is like almost having a green card. Not exactly though, but under the current conditions though, having an I-140 is very good. You are thinking that, okay, this end client company is going to give you, they said they're going to wait period is 1 year. You think so after 1 year, they will just file the green card application? They will start the green card application at the time. And in the 1 year, there's a rule where I have to tell you this whole story that, one of the guy goes to the king and the king tells this guy, hey, you make my horse speak, otherwise you're dead. You make it speak within 1 year. And this guy is roaming happily and all those things. Everybody asking, you're going to be dead in 1 year because you can't make the horse speak in 1 year. We all know that thing. In 1 year, the king may die, I may die, or the horse may speak. In your case, that 1 year, who knows? Anything could happen there. Anybody can change their mind in that 1 year period. Now you have this company filing an I-140. Please, if I were you, I would stay with the company. I don't care about a better job. I want immigration peace in my life. And maybe I'm just designed that way. Being an immigrant and immigration lawyer, first an immigrant, then immigration lawyer, yeah, I would choose I-140 over the customer job that you're speaking about.
Aspa says, I'm on H-4 visa in the U.S. I have an H-1B approval for consular processing from employer A that's valid till 2025, but I never got the H-1B visa stamped. Can employer B file for a cap exempt petition as a change of status? Technically, no. So although you have that approval notice, because it's consular processing, you're not considered to be counted in the cap until you either get the visa stamp or get admitted into H-1B by having that change of status approved and take effect. So we've seen time and again where people tried to do this and they got the transfer, the change of status denied on the grounds that you need to go through the lottery again. You're subject to the cap because you've not actually been counted. That being said, we do see some random approvals. There's always a chance that later they could come back and revoke that approval if they realize that it was issued in error. So you may want to, if that original job is still available, get the visa stamp or ask that company. Company A can file a change of status from H-1B from H-4 to H-1B for you because they already have the approval notice. And then once you have that, you could potentially transfer to company B.
Uh, Clive, Clive 26 has this question. Do you think the rest of the world will become current with the tax layoff, or it doesn't matter? Here, the rest of the world are already current right now, technically speaking about, because December 2022 or November 2022 is only like 3 months ago. If you are a regular labor certification filer, though, the labor certification must have been filed a long time ago, at least 7 months ago. So your date for most of the EB2 and AB3, technically speaking, the rest of the world is current right now. So if you're eligible for it, please file the 485 right now. Don't delay it. Now, why I don't think so, the tax layoff may not improve the situation for the rest of the world, because we think so that somehow the international people moving from one country to another country, migration, immigration in the world has increased to a greater extent. Though people who were hesitant in moving to USA are now moving to USA, and vice versa in some of the cases too. So because of the influx of the rest of the world more, it may become backlogged in the future, even though it may not be technically backlogged right now, but it is expected to get backlogged. That's my expectation. I can go wrong. The other reason why I think so that the rest of the world might go back more is that in this year we have extra green cards coming into for the employment based green cards, though. Because of the COVID last year, some of the USCIS and consulates were closed. So because of that, some of the family immigration green cards came into the employment base. We don't think so that that will be the trend in the coming year. So starting from October 1st of 2023, we may see some more backlog in the rest of the world as compared to what it is right now.
RV says, does a second concurrent H-1B need to be for 40 hours, or can it be for 10 or 20 hours based on the need of the second job? It does not have to be for 40 hours. It can be if you want to work 2 full-time jobs, that's totally fine, but your concurrent second job can be part-time. Even the first job technically can be part-time. 10, 20 hours is fine. You can put a range of hours if it's going to vary from week to week. Any of the above is fine.
Um, this question comes from he's a Canadian citizen on H-1B employer. If the employer starts a green card, will it affect the TN visa of the Y family?
If the employer starts the green card?
No.
No. So the perm filing does not impact the TN. The I-140 filing can. So you would just want to make sure you're timing the filing of the I-140 around any TN renewal that may need to happen. But otherwise, and is it going to impact for the wife? It could, but
we haven't
I don't
seen
think
that.
so. There's no question, because the immigrant petition has not been filed for her. So when she's filling out the, she wouldn't need a DS-160 if she's a Canadian citizen. But when she's applying at the port of entry for that renewal, she never has to say, I had an immigrant petition filed on my behalf. It's her husband did, and that question is generally not asked. I don't see much issue.
One of the other thing, Nishant, you may consider that if I were you, is to get the I-140 approved and after the I-140 is approved, though, you can actually change your wife's status from TN visa to H4 plus EAD. And that one step you can do. And while on H4 EAD, you can even try your wife on the H1 lottery system. That's one other thing she can even do right now also, because if she's on TN visa, most probably they may do H1B. You can consider those other options too. I want to revisit the question faced by RV Emily with regards to the second concurrent job. Should it be full-time? As you said, both can be full-time. Well, these computer guys are, these are lazy bummers. They don't work 80 hours like lawyers and doctors do. So there's nothing wrong in working 80 hours a week, guys. Nothing wrong in it. Like doctors do it, lawyers do it. You guys are lazy guys. I know that. Bill Gates once said that, he hires only lazy guys because they will figure it out how to do it easily. Yeah, that's one thing. But I normally recommend people to put the second and concurrent file job. Can they put a range of hours there? So can they put like 5 to 40 hours?
0 to 40.
1 to 40, yeah. So yeah, you can put anywhere from 1 to 40 hours, and in that way, the concurrent employment can actually employ you for whatever time period. Some weeks, maybe 1 hour. Some weeks, they may do 40 hours. Depending on how many hours you work, they can start paying. So I normally recommend people to put 5 hours to 40 hours. So that's up to, and then they can give you employment for 5 hours or 40 hours. The range can be prescribed in the LCA so that there can be variations in the concurrently filed H-1Bs.
Enrique says, after I get my H-1B, when can my company start the process for getting the green card? Immediately. You don't have to wait at all, and we recommend not waiting long because that process is taking longer and longer. You just should expect it to take 2 years just to get to a point of having the I-140 approved, and then depending on your country of birth, if you can file the 485, that may be another 2 years for that to be processed based on current processing time. So start early. As soon as you have your H-1B, you're good to go.
Emily, is it required that he needs to have a H-1B to file the green card application though?
Definitely not, no.
You mean to say if he's an F1 visa, they can apply a PERM application, even if his H-1B is not selected in the lottery?
Yep. Yeah, we have a number of people that are, early on in their F1 OPT time where they have the STEM extension option, so they have almost 3 years. Their company is going ahead with the green card process, and they're doing the H-1B lottery just as a backup, but they very possibly could get to the point of having the labor I-140 approved and 485 filed and get the EAD before their STEM extension expires. And so avoid the whole H-1B mess.
So in other words, if they are from the rest of the world, they can skip the entire H-1B lottery and directly go for the green card. Yes, we do at our office quite often these things. We think so that H-1B is a waste of money for the rest of the world. But, as a backup plan, I always have it. But that should not be the primary plan if you are from the rest of the world. Now, of course, for Indian nationals, so H-1 becomes absolutely necessary.
Ash says, my 485 was filed in November 2020, but then in September, I did the interfile to change the underlying basis, and now I have a job offer, but it hasn't been 180 days from the time I submitted that supplement J. Do I need to wait? I've not seen any negative outcomes of people who didn't wait 180 days after submitting that supplement J to transfer the underlying basis, even though USCIS said on its website that you're required to wait 180 days. I don't think there's any basis in the law that allows them to make that statement. I think that if they were to deny your 485 because of it, they would be open to a swift lawsuit. But that is the guidance. So the guidance says wait 180 days, but
we haven't seen any denials at all, none whatsoever. Hello, NK has this question. I don't have a marriage certificate, but submitted affidavits. What are the additional documents? You can always keep additional documents like living together documents like lease, income tax returns, bank statements, child birth certificates, utility bills pointing out to the same address, driving license pointing out to the same address, any of the marriage pictures. But NK, sometimes we are noticing that the USCIS officers want the marriage certificate though. So if ever you go to India, you can register the marriage right now also. If you and your wife are visiting India though, you can still register the marriage there. And people ask the question, no, the marriage will be registered in 2023. We got married in 2013. Yes, you got married in 2013. The registration will be done in 2023, but they will put the marriage date of 2013 in India. There are ways. All you need to do is that show them your marriage invitation card. If you have it anywhere, they will take that as an evidence and give the marriage certificate in 2023 saying that it's registered in 2023, but the marriage date is in 2013. You can still do that, not a problem. By the way, I'm a lawyer in India and I'm also a lawyer in USA.
All right, well, we are out of time for today. Thanks so much for joining us. Don't forget to subscribe to our YouTube channel if you're new here so that you'll be notified of any of our upcoming videos, both of our lives, and we've been adding a lot of shorter videos on special topics and things, so please check those out. And you can always subscribe to our newsletter by going to rnlawgroup.com.
Thank you very much.